Thank you for being here this morning, members of the board, and it's good to see all of you have this important matter that the superintendent will brief us on in a second. But it's always important when we do something of this magnitude that we have the whole board here, because it's significant, and it deals with it has a lot of ramifications because of the amount of money we're dealing with, not only for the sale of the property, but also the monthly income we get from it. So thank you for being here. And with that, we're going to go to item 2. 2A, discussion action on the possible approval of amendment to a lease with Chiricahua Community Health Services related to A Avenue School to extend the closing date and term of lease. Ms. Samaniego.
Good morning. Yes, and thank you for being here on such a short and inconvenient day, but we've got to take care of this. So as you saw in your background information, I provided a bit of details from our attorney as to what we're dealing with now. So last week I was contacted by Dr. Melk, CEO of Chiricahua, and we had been moving right along to closing. So closing was going to take place by, I believe, December 31st of 2026. Everything was working out smoothly. When we've been interchanging, documents with the Pioneer Title Agency. I mean, we were on track to close. So in the last steps of this whole process was obviously looking at the deed of the property and everything that the title company has to do. Well, they found that in the deed of A Avenue School, there is some language in there and stipulations that now prevent us from moving forward until this is taken care of. And basically what it is that in the deed, there's a Douglas Investment Company that was the foundation of the original, I'm going to say, and correct me if I'm wrong, Mr. Bahrain, the Douglas Investment Company, who were the original founders or built this building and then donated it to Douglas Unified School District. So in the deed, there is some language in there that says that Douglas Unified cannot sell it to anyone for business purposes. In this case, Chiricahua is a business. And so this deed was originally created and done 107 years ago. And so Dr. Melt called me and said, that they had found this out in the deed, and therefore, obviously, the lender is a little uneasy about moving forward because of that language. And so there's a couple things that would need to be done on behalf of Chiricahua, not DUSD. And it is to try to either, one, find if there's any descendants of the Douglas family that would be willing to give us something, a written statement, allowing us to sell this for any reason, including a business. Two would be to see if the Douglas Investment Company is still a viable and practicing organization, or did they dissolve it because this was done 107 years ago? And if so, then if it's dissolved, there are some statute of limitations with things like this that our attorney said we could take, but it would have to go to the court. And so then the court would then deem that, this was dissolved and therefore null and void on whatever language or clause in the deed, allowing us to move forward. So after looking at this new recent information and discussing it with our attorney, discussing it with Chiricahua's attorney, they both spoke, and the recommendation was to bring a new amended agreement, which would allow an extension of 90 days initially, but also there's language in there that if this is not taken care of in the 90 days, that we could extend it up to 2 times, allowing us for a new closing date of June 30th, 2026. Chiricahua is still very interested in purchasing. They just need this extra time to be able to figure this matter and take care of it. And so our attorney says that it is doable, but it's nothing that we have to spend money on. It's something that Chiricahua has to do and figure this out. If by extending the new amended agreement, we're going to continue to rent the facility for the same price, and then if we find out from Chiricahua that this can't be taken care of, right? And let's say we would then determine if we have to take this to the court, then that would be another conversation, and then at which point we could discuss of doing an extended indefinite lease and looking at a different price if the sale doesn't go through because of this little factor. But this corporation or company was originated 107 years ago. And that is why we're here today, because of the closing date, and which we were very confident that it was moving along smoothly until they found this out.
Yeah, it's interesting to me that every time we discuss some type of a transaction with Chiricahua, and again, as I mentioned earlier, it's significant, they never have a representative here. It's always the report, which is always very thorough and accurate by the administration, and we're grateful for that. But the fact that there's no representative here, in light of a lot of other things that are kind of revolving around this whole issue, is that we don't have anybody here that we can ask questions of from what their intentions are, what would happen if we didn't increase, if we didn't extend the lease. And then there's another factor here that this board could also, because of the changing factors in the market price for whatever the value of the rent would be now, we could even increase it if we wanted to, because we're looking at an extensive period of time now that could be significant to us, especially when we look at the state of our finances and the fact that, and we'll be very open about it, the fact that the district is depending heavily now, as a matter of fact, on that monthly rent. And then that's not even withstanding the potential sale. So no representative, no interaction with them, and no information except what we get from the administration. And then the other thing is, other than the increase in the rent, is why did our attorney draw up the? It seems to me that we had to pay our attorney to do this, right? To draw up that agreement. Why should we bear the brunt of that cost? It's incumbent on them, they're the ones that are asking for the extension, that they draw up the lease, and that they present it to our attorney, and our attorney says, like we do other IGAs and agreements, in contracts, our attorney says, we reviewed it, the language looks good. But no, we had to pay our attorney to draw up the lease. So again, it goes back to what is their interest. To me, it seems like they always think it's a fait accompli that the district is going along with anything they want to do. So I'm going to, first of all, members of the board, before we get into any discussion with the board, could you address any one of those things that I mentioned? First of all, about the increase that we could potentially ask for, or the fact that they didn't draw up the lease, they pay their attorney to do it, and then it's presented to this board by way of our attorney saying, yeah, that lease is legal, it's in the best interest of the district, go ahead and sign it. That's the way most things are done, most of the time. So go ahead.
Well, as far as the increasing of the rental, beyond, let's say June 30th, or beyond this month, and Curtis did as we were working on this Thursday and Friday while I was.
Curtis, the attorney,
Curtis,
so
our
the board
attorney, from Udall Shumway. So he did ask, if we could extend for, let's say, the 90-day, and then extend it beyond that for twice the timeframe for up to June 30th. And he said because of the timeframe of the December 31st, we wanted to get this to the board. And the reason that he's drafting this is anytime that I bring something to the board, at least with this matter, has always been drafted, between both parties, but in communication. But our attorney is the one that drafts and looks at, and then they share it with their attorney. They take this out, add this, and all of that. So there's communication between both legal entities. But from my experience in this, our attorney has been the one that's been providing these lease amendments and all since it originally started back, when the first time that it was
Okay.
done. So that's what I know, why he's drafting this. And if the board decides to entertain beyond, let's say, even the first 90-day, and say, what, we have, they're asking, this amendment allows us to continue past the first 90 days, because the language is already in here, but I can always come back and work with Curtis and say, okay, so now we're in the second 90-day term, I'd like to consider a price increase. And so at that time, we could come back and have that discussion because of the price index and, and possibly the price, going up. Cesar, what is the rental right now amount?
It's, I don't have the exact number with me, but it's $14,075, I believe.
Around there, okay. And so, the fact that, their attorney and directly contacted, because when Dr. Melt called me, first of all, to tell me of this new issue that they had run into, instead of him telling me and me calling back, and he says we need both of the attorneys to work together, and that's what they've done. And that is what the outcome of this discussion is. And our attorney believes that they could take care of it in the 90-day period. And dealing with this matter here, and hopefully then the sale goes through in the 90-day, even before, because this allows that if they take care of it sooner, then the sale can go through a lot sooner than the 90-day extension or the June 30th timeframe. So that's what I can tell you, Mr. Bahrain. Their intentions are to buy the property. Their board has already approved it. They've given Dr. Melk the authority to move forward and continue with this process. And now that there's this information on the deed that their lender is, uneasy about moving forward and funding the project, funding the purchase of it because of what it says in the deed.
Okay, thanks for that clarification. Only for discussion, let's get a motion on the floor so that the board can be thoroughly informed by wherever the discussion takes us. Mr. Lennon,
I move to approve the extension agreement.
is there a second?
Second.
By Ms. Selchow. One of the things that the first 90 days, and I don't remember specifically, but after the first 90 days, if we approve this agreement in its entirety, that would mean that, would it automatically, if they come back and ask the administration, would it automatically roll over to the next 90 days?
Yeah, well, there's already language in here, Mr. Bahrain, that will allow that without me having to come back to the board.
Okay, that's
Mhm. Yes,
the
already in
question. So
there.
that's something we need to know, that if they, for whatever the reason, they can't get that deed cleared up, the administration has the authority from the board by the action that we could take here this morning. Okay, discussion. Members of the board, Mr. Smith.
I'm a little bit leery about the whole thing. Have we seen this, a copy of this deed?
Yes, they've sent me, the attorney has seen it, Cesar and I have seen it.
It seems very convenient that, back in 1918, they would put a clause in there saying that, You can't sell it for a commercial, but you can lease it for commercial, which is basically what we've been doing and what we're trying to agree on today. We just can't sell it. I mean, that's kind of a specific and, convenient for, stalling. And the reason I'm kind of thinking that is because that's mainly what I've seen from Chiricahua so far. Whenever we discussed this before, they were supposed to have a final decision on whether they were going to buy it or not by October, if I remember right. We hear something in December. And then what we're hearing is that they're wanting basically another, what could be a 10-month extension, 30 days plus 30 days plus another 30 days plus a month to close everything out. You add it all together, you've got nearly another year there that they're stalling on making this purchase. It just seems kind of convenient, and I wonder what, add to that the fact that they don't even bother sending a representative here to discuss it with us or anything. Makes it wonder how much their intent is, or whether they're just stalling for time trying to raise funds to do this. So, like I said, the fact that this deed is so specific from way back then, to me, is kind of circumspect. And I wonder where it came up from. Now they're trying to, you said part of what the way to fix this is to find out whether the organization that put this in there even exists anymore. I don't know. It just, something seems off about the whole thing, as far as I'm concerned.
The thing that's a little confusing, and Anna said it was 107 years ago, and she said, maybe you, Mr. Brain, have some insight. I'm not that old. But anyway, is the fact that, and of course, I'm just kidding. But the fact is that I know that the building was, the funds that were used to build it was a bond issue. And so evidently, the Douglas family had to have donated the property and put that stipulation in there when they donated the property. So that's something that's interesting that you mentioned that they didn't, they could, we could use it, and they are using it as a business, but we can't sell it as a business. That's a little conflicting. So.
And if I may, Mr. Brain?
Go
can
ahead.
I'll read you what, because of, I asked that same question, Mr. Smith. So we've been renting it as a business,
Right.
and that's what our attorney said, yes, and nobody's contested it. So this is exactly what it says. That said premise shall not be used in any way for the purpose or trade or business. That's the one line. And so even our attorney said, you've been renting it to a business for the last 10 years and nobody has contested. So that's why he sees that this can be taken care of. He said, we did not know this even existed, and neither did Chiricahua until now that we were going through all of the title documents, because everything was going through the title company. And the title company is very involved in all this, and that's when this was reached out. But that's all it says, and that's in the deed.
So
it's that one line.
with that being said, that as long as it's not contested, it's not needed, who are the people that could possibly contest this? It would seem like it would have to be one of the parties involved, either Chiricahua or us. If we're wanting to make the sale and they're wanting to make the sale and neither one of us contest this, how is this preventing the sale from going through?
Well, that was initially when she advised me of what was going on. That was my initial reaction was, who's going to contest it if we continue? But I can see the apprehension on the part of Chiricahua and their attorney that maybe somebody comes out of the woodwork one of these days and says, and then they would have another problem. But that would be. And I think she discussed it with Curtis that I said, why don't we just move forward with it? But Chiricahua doesn't want to. They don't want to take that risk.
And it's not so much more Chiricahua, it's the lender. So the lender who is putting out the money for their whatever to buy the property wants that taken care of.
Which kind of goes back to what I was thinking about earlier, where it almost seems like a stall tactic. Because from what I've heard, Chiricahua's been going all over the state trying to raise money through grant, through loans, through everything else. And, you know, now that they were basically being pushed by their own agreements where they're having to make a decision, they come up and say, oh, well, you know, but yeah, we've got a problem where the lender not wanting to do it. Why is that our problem?
Well, I think, Mr. Smith, if I can just interrupt you for a second, Caesar, they never default on the monthly payment, do they?
No, they haven't.
So that in itself, I don't know if that's indicative of what the future would hold, but the fact that we do get that $14,700 a month is, especially now, is very, very
Sure,
significant.
that's, yeah.
Yeah.
And again, I can see where extending this is obviously a benefit to the district, and I'm in favor of that, because anything that benefits the district right now is favorable. I'm just kind of, as I said, every time we've discussed this, it just seems like it keeps getting postponed and moved, and, you know, that's not us doing it, it's them. And it makes me wonder how serious. So, yeah, they can obviously come up with $14,000 a month. If we go through the sale, we're not planning on financing it for them, is that correct?
No.
They're going to have to come up with the cash,
Yes.
you know, to finish it up. Well, then, I guess it just depends on whether or not we want to keep letting them extend and keep going while they try and figure out what they're doing.
Ms. Salcho?
Okay, typically in real estate, the seller, the onus falls on the seller to make improvements unless you sell it as is. But where does the cost usually fall in this, the paperwork of the deed investigation? Because I don't see that it falls on us.
No, and it won't.
Okay,
That
that's
was
what I want to
something
know, is that
I-
all legal cost will be
That's on them.
assumed by the buyer? Okay.
Because that is their responsibility. If they want to buy the building, then they have to do, because I asked that question to our attorney, and that's the first thing that he said. The determination and any expense related to clearing this up is not going to be on DUSD.
Does that also include our conversations with our lawyers? Because we do get billed.
Yeah, and I think, and that I don't have an answer for that.
Okay.
All I know is that we get billed whenever we speak to, even as an email or a phone call.
All right, and it adds up. And so, and in light of things financially in our school district, I just think that that's something that could be possibly looked at as well, is if we're having to go to a lawyer for advice for this, then will they be assuming those costs as well?
Mr. Lindeman?
Well, first of all, I'm wondering, does anybody still, or does anybody know who the original people were? You know, and then we can backtrack and see if they're still in business, or if they're still an entity.
Well, and that is what Chiricahua has to find out. Because
Well,
that's
that-
not something that we will do.
Because if it goes to a court, that in itself could take years.
And
you know,
money.
and money, and so,
Right.
you know, like you were saying, the stalling tactic, boy, that could be a long time. I think we should just raise the rent. So, anyway.
Mr. Ramos?
Well, 14,000 or roughly about 168,000 a year, but we get a rent. If they're gonna purchase the building, I don't know what their monthly premiums are gonna be, but it's gonna be pretty close to what they're paying rent right now. So they're asking for an extension to go in for 90 days. and in 90 days, we have an additional 90 days. We can do that 3 times. That
Yes.
would be- So, I'm thinking, are they stalling? Because you haven't talked to the lender himself, have you?
No, and you know, that's
It's only
not.
what they tell you what's going on.
And the title agency, you know, we've been in direct contact with the people from the title agency who's been the one doing all the documents, and so it's not only Chiricahua, and then the attorney and our attorney have spoken.
I personally, Mr. Ramos, I think it's a legitimate concern of the lender. I don't think they're stalling, to be honest with you.
Okay.
If that were the case, I think we wouldn't even be here this
Yes.
morning. The superintendent would have talked to Curtis, and they would have had that whole thing resolved
Yeah.
legally, but I think it's legitimate.
Yeah, I don't think they're stalling either, to tell you the truth,
Okay.
just because there's been other people involved other than just, you know, the people from Chiricahua. And so, I think it's in the best interest right now, like Mr. Smith said, to go ahead and approve this. And if we get to the point where we are at the end of the new closing time, then I think that would be appropriate to say, okay, what are we gonna do now? The sale is done, it's not going through, we're gonna now raise the rent, and this is the terms of the lease agreement, and we move forward.
I think it would have been very convenient for the board and beneficial to the board had they had somebody here to address some of the questions and concerns that the board have. But again, never, not that in my tenure that we've dealt with them, have I seen a representative here at any time to either propose or speak as a proponent for the issue, that they're never here, and that's disappointing. Before we get back to the board for afterthoughts, Mr. Soto, do you have anything you want to add based on the discussion that you've heard here this morning by the board and the superintendent?
Yes, Mr. President, I was about to mention the conversations with Dr. Mel some time ago. The important, and I agree that they're not trying to stall the process or anything like that. It's very, very convenient for them to actually purchase the building, because that would facilitate them getting grants. He mentioned at one time that because they're leasing the building, they're not able to get grants. So that's just to clarify that point, or to make it a little bit more understandable that they are very interested in the purchase of the building, just so they can start applying and getting funding federally.
Mr. Soto, not to in any way compromise the board, but would you address that $14,700, what that's presently being used for? That's very important, because that's one of the funds that Mr. Soto assured the board last year that he didn't think we would have to be using this year for the insurance that should be coming out of the M&O, along with another fund that we're having to tap to pay for the insurance. So, but go ahead, Mr. Soto.
Just to clarify it on the amount is $14,075, not $700. But
Oh,
yes,
okay.
that money is going to the Fund 500, which potentially we're going to be using to help out on the health insurance for employees.
So if we didn't have that, it would really exacerbate the situation we're in right now financially with everything else. So, as I said, I don't want to put any undue pressure on the board or compromise the board, but if we were to continue with the lease and we were to approve this morning, it would continue to contribute to that situation that we're having to address now anyway. So, did you have anything else you want to add?
No, not at this time.
And your recommendation is to
It's
go along with
to
it?
go along and to approve the amended lease.
Okay, Mr. Smith, any thoughts?
Does anybody know what the square footage of that property is?
I don't, do you know, Mr. Soto? I don't have that information.
Oh, no, I
No.
don't have that
Okay.
figure in front of me.
I'm just
sorry.
kind of curious what the going rate for commercial property is for leasing and that kind of stuff to see where we're falling into place on what we're getting for rent. As we said, I think right now, if we approve this, we're basically giving them another, at the very least, 9 months, possibly 10 months of rent at whatever we're being charged now. How does that stack up with the rest of the community, with the lease square, price per square foot of
What
the
I-
commercial leases?
What I will say is that the amount that we are currently charging has been based on the current going rate or for commercial properties, and so there are some formulas or things that our attorney has been well aware, and that's the recommendation that he gave. So if we were to extend beyond, let's say, even the June 30th, I think at that time, I would come back to the board and say, this is our new recommendation for an extended lease with a new rental agreement, and then our attorney would be involved, has to be involved according to the new price index.
Are you done, Mr. Smith?
Yes.
Ms. Salcho?
I have nothing further.
Mr. Lindeman?
No.
Mr. Ramos?
No.
Anything else?
No.
So we have a motion on the floor, and always omnipresent is the responsibility and the stewardship of this board. And we're ultimately responsible for the finances of this district. Of course, our priorities are always the children, always the students, the education. Second is their security and the security of our staff, and always to try to do the best we can financially for our staff. So keeping that in mind, we're always ultimately responsible. And this is a factor that we will be addressing in the near future regarding some of the other issues that we have financially, or that we're seeing down the road that is going to be inevitable that we're going to have to address. And this is a portion of it, because it deals with revenues. So keeping all of that in mind, if there's no further discussion, call for the question.
Mr. Smith?
Yes.
Ms. Salcha?
Yes.
Mr. Lindeman?
Yes.
Mr. Ramos?
Yes,
Mr. Breen?
Yes, and Ms. Samaniego, although you do have the approval to do it, you definitely will,
Yes.
if it gets to that point,
I
you
will.
definitely will inform the board.
Yes, I will.
All right, anything further you have this
No.
morning? Again, thank you, board members, for being here. Entertain a motion to adjourn
Move to adjourn.
by Mr. Lindeman, second by
Second.
Mr. Smith. All those in favor signify by saying aye.
Aye.
Thank you for being here. We stand adjourned.